Now, if somebody copies your trademark and uses it for similar products or services without your permission, then that will amount to trademark infringement. Trademark infringement determination is based on two primary steps. First step is to determine whether there is double identity. This is called as double identity test. The second question is to determine whether that particular person who is copying your trademark has copied it in such a way that there is likelihood of confusion among consumers. Right? So this is called as likelihood of consumer test. So as you can see, everything in trademark law is based on consumers, consumer perception, consumer association, consumer recognition, and consumer decision. If a consumer feels this is infringing, it will be infringing. Right? So law has evolved around it to come up with some tests which will place consumers in that particular position and then make a decision based on that. So trademark has two tests, as I pointed out, double identity test and likelihood of confusion test. The first step includes two questions, the double identity test. First question is, are the trademarks identical or similar? If the answer to this is yes, then the next question is, are the products or services to which the trademarks are being applied identical or similar? If both are yes, then you satisfy the double identity test. Note here that they must be identical or similar. You are not only looking at exact identity, but also similarity. Then the second question is, if trademarks are identical or similar and products for which they are applied are also identical or similar, would this cause confusion among the consumers? If it is likely to cause confusion among the consumers, then there is trademark infringement. Otherwise, there is no trademark infringement. Now, who is the consumer with respect to whom this confusion has to be caused? It is a consumer with average intellect and imperfect recollection. So, if the double identity causes confusion among consumers of those products or services who are considered to have average intellect and imperfect recollection, then there will be trademark infringement. Trademarks extend to domain names also. Now, if you have a registered trademark and somebody is using a domain name, you don't actually need to go to court. There is a procedure called as domain name dispute resolution process. If it is a .com, there is uniform domain name dispute resolution process. If it is .in, then you have INDRP, where is an Indian domain name dispute resolution process, where an arbitrator will come and decide your case within 60 days. You can just file a case against the domain name and the arbitrator will decide the case within 60 days. It's quick. You can also do it on your own. You can also approach a lawyer. It's also not very expensive. Okay. Now, in trademarks, you also have passing off and dilution as remedies. Passing off is normally available for unregistered trademarks. Even a registered trademark, in a case with respect to a registered trademark, you can claim passing off. To prove a case of passing off, you have to prove that the other party is misrepresenting your trademark to be yours. In other words, if another party is selling water bottles using your trademark, that person is using the trademark, and in order to show that it is the source of origin is you and not him. Right? So he's placing products in the market and taking advantage by selling those products in the market by misrepresenting a trademark and its source of origin. And then that misrepresentation is causing damage to you. Right? These two are very difficult to prove. And therefore, infringement is much more objective and straightforward. And so it is always good to register a trademark rather than fight a case for passing off. Then trademark dilution is a remedy that is available for well-known trademarks. If a trademark becomes very popular, then that trademark gets the capability to stop people from using the trademark even in unrelated goods or services. And if somebody uses a famous trademark with respect to unrelated goods or services, that is referred to as trademark dilution. But this remedy is not available for trademarks which are not well known. And to prove that your trademark is well known, there are a series of factors that you will have to satisfy.